listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to the Driving Law podcast. I am Kyla Lee, the host of the podcast, and with me today is absolutely nobody. Yes, that's right. Paul is sick. It's not the sickness I had that I toughed through on 2 episodes to do a podcast. It's a different illness. I didn't get him sick, I promise. But yeah, he's apparently too sick to do the podcast, and nobody else at the office agreed to do it or step up. So you just get me this week. And sorry for the boring one-person perspective podcast in advance. But I thought this would be a good time to talk a little bit about an endeavor I started recently that I haven't mentioned on the podcast. And that is my Impaired driving newsletter. So for the last 15 weeks, and yes, I started this 15 weeks ago and have not mentioned it on the podcast yet, which is a bit of a shame. I have been publishing a newsletter that is also published on CanLII. So it is a CanLII-published newsletter for impaired driving. It's called the British Columbia Impaired Driving Newsletter. If you are a subscriber to like any RSS newsletter feeds, you can subscribe to it and get it in your inbox. But you can also just find it on CanLII on a weekly basis. It comes out every Thursday. And each week, we cover off a tip for impaired driving defense, whether it is criminal code impaired driving defense or immediate roadside prohibition defense. It's just kind of what's boiling around in my brain in that moment. And then we also cover off a decision of the week, usually a decision in which I was successful in some sort of argument. So the impaired driving or IRP decision of the week will be in there every week. And then also a DUI decision of the week. So a criminal court decision dealing with impaired driving. And I thought I'd give you a little preview of what was in this week's newsletter for the decision of the week, because the decision of the week from this week is actually something we probably would have talked about on the podcast, Paul and I, had he actually been here. So the case is called Ingabir. It's 2026 ONCJ 102, and it was an impaired driving over 80 case. And there was an allegation of significant charter violations committed by the officer. The accused argued specifically that their Section 7 rights were violated, as well as that the police violated their, Section 8, 9, 10B rights by not making a lawful ASD demand and administering a lawful ASD test. And then finally, in the implementation of the right to counsel, the police also violated the accused's charter-protected right to obtain and instruct counsel of choice. A very interesting case. Ms. Ingabir was stopped, and the police formed a suspicion that there was going to be an approved screening device test conducted, suspicion of alcohol in the body, and approved screening device demand was made. But then the police didn't administer the demand or read the demand to Ingabir. I'm not sure I'm pronouncing it correctly, for 3 minutes. And again, we've seen short periods of time very problematic lately in our legal system. We talked before on the podcast about the Saskatchewan Court of Appeal decision in McColman, which was 5 minutes. And we also talked about the Saskatchewan Court of Appeal in Westgard, which was 2 minutes. This case, we have 3 minutes of delay reading the demand. And the reason for the delay was that the officer was questioning Ingabir about things that the court characterized as accusatory and incriminating. Specifically, asking Ingabir not just like whether they'd had anything to drink and when their last drink was, which are normal roadside questions, but also where they were coming from after forming this suspicion and before reading the ASD demand. And what type of wine, after Ingabir admitted drinking wine, what type of wine they had to drink. And this accusatory, incriminating questioning took place over a 3-minute period between the formation of the suspicion and the reading of the demand. And the court found that that was unlawful questioning. Not only was it problematic in terms of the right to counsel and the fact that you need to be given a caution when you're being asked questions that you're not required to answer, and when things are being delayed for the purposes of asking those questions, and read the right to counsel, these things didn't happen. So now we see the law really trending. This is an Ontario provincial court case. The law is really trending in a direction of recognizing that even very brief delays are still nevertheless significant violations of the immediacy requirement for the approved screening device demand. And, back in the forthwith days, it used to be that if the delay was less than 5 minutes, it wasn't a big deal, right? People didn't care about a delay of 4 minutes or 3 minutes. There was actually an Alberta case once that found that a delay of 1 minute was too long, but most of the time, if it was anywhere up to 5 minutes, the courts would kind of excuse it. But now, immediately means immediately. And it's nice to see that explicit word in the criminal code being given its ordinary explicit interpretation. So anyway, Ingabir does the approved screening device test. She fails the test, and then the police read her right to counsel, take her back to the detachment, and she gives the name of a lawyer, a specific lawyer that she wants to speak to. This lawyer happens to be a lawyer who practices in the area of real estate law, not a criminal lawyer, certainly not an impaired driving lawyer. And so the officer, pursuant to his obligation to facilitate contact with counsel of choice, places a phone call to the real estate lawyer, who answers the phone. And the officer explains that Miss Ingabir is in custody for impaired driving. The lawyer says, yeah, I'll talk to her. And the officer says, great, I'll call you back. Hangs up the phone, and then goes to Miss Ingabir, does not tell her that he spoke to her lawyer of choice, that her lawyer of choice was available and willing to take the call, and that he just needed to call the lawyer back. Instead, he told her that she couldn't talk to that lawyer because the lawyer was not available, and then misled her into thinking, because her lawyer didn't answer, and telling her, oh yeah, I left a message, but you can talk to duty counsel, and really encouraged her to speak to duty counsel, leading her to believe that the lawyer wasn't going to be available that she wanted, and that speaking to duty counsel was really the only option. So he never tells her what actually happened in respect of her right to counsel, lies to her about it, lies to the lawyer when he says he's going to call them back and isn't. And the Crown, if you can believe it, actually argued that this was good faith on the part of the officer. The officer's explanation for this at trial was that it didn't make sense for her to talk to a real estate lawyer because a real estate lawyer wouldn't be able to advise her about criminal law. And that's not true. That's absolutely not true. Just because you're a real estate lawyer doesn't mean you don't have knowledge about criminal law issues. We all have to pass the bar, which involves questions on real estate and criminal law. Lawyers routinely change practice areas. Lawyers sometimes have different practice areas at the same time. You might practice criminal and administrative law, for example, or you may practice real estate and criminal law. I mean, I doubt there's many lawyers with that combination. You may just be really familiar with criminal law because it's of interest to you. But that's the decision for the accused and the lawyer to make. The lawyer to decide whether he's competent to give advice, and the accused to decide whether she wants to speak to a real estate lawyer instead of a criminal lawyer, and not to be making that decision after being misled about the availability of her counsel of choice. So the court, I think, quite clearly did not buy the Crown's good faith argument, and found that this was some pretty egregious conduct on the part of the officer, who actively worked to undermine the constitutionally protected right to counsel by lying, which is so worse. I can't believe the Crown actually ran this case. The idea that they ran the case and advanced this argument with a straight face boggles my mind. Because what judge would ever find that a police officer could just take over somebody's right to counsel, mislead the accused person about their right to counsel, mislead a lawyer, and that would just be, good faith? Absolutely not. It's shameful that this case even made it to trial. In any event, the court obviously found, given the egregious and seriousness of the breach, and given the fact that the ASG was unlawful, the samples were obtained unlawfully and in violation of the right to counsel, and the court excluded them from evidence. Obviously that left the impaired driving count, but the only evidence on the impaired driving count was an odor of liquor and the fact that Miss Ingebier had been in an accident, which the court basically said that this evidence is way too frail to justify a conviction, even on the very relaxed standard of impairment to any degree, even slight, under Stellato, still not sufficient to justify a conviction. And yeah, it really is difficult to envision a case where the police act in a worse way about the right to counsel. Like, I've seen some pretty shocking things in my time, like police going into the lawyer room and hanging up the phone on the lawyer while they're in the middle of giving advice because they felt too much time had passed. But like this, like the deception, the forethought into the deception, the attempt to justify it with like really spurious reasons, all of that is just gross. So I don't know how useful this case is to people on the 10B issue, but it's certainly useful on the very short delay issue. So definitely something that you want to have in your arsenal, which is what my impaired driving defense tip of the week was in the impaired driving newsletter. Specifically, you should be maintaining a list or a database somewhere of impaired driving decisions. This is one of those areas of law where, as a judge once told me, if you look hard enough, you can find a case that says anything. And in the circumstances here, this is an example of a case that says anything, something you wouldn't expect it to say. Um, Before we move on to another decision I want to discuss in the impaired driving context, I wanted to take a moment and talk about Bill C-22. This is a bill that was tabled yesterday, Thursday. The text of the bill has come out, and it's basically a re-envisioning of Bill C-2. C-2 was a bill that dealt with the police access to your online and digital activity, essentially trying to lower the standard for police to get information about what you're doing online, to search your computers, to engage in mutual legal assistance with other countries, and to compel telecommunications and technology companies to turn over certain information to the police in investigations just on demand without the need for judicial oversight. And you might think, Kyla, what does this bill possibly have to do with impaired driving or driving law? And not a lot, but there is one thing about the bill that does touch on it. And that's that police can obtain something called a tracking warrant. And a tracking warrant is a warrant that the police have to get. They have to go to court and justify why they can use methods to track somebody, like put a tracker on them. And they can obtain a tracking warrant currently under the existing legal system. But under C-22, the standard for police to get a tracking warrant is going to be reduced to reasonable suspicion as opposed to reasonable grounds. And not only that, but the tracking warrant is going to be the tracking capabilities are going to be expanded if this bill passes. So instead of saying that like a warrant can track a specific device, like somebody's phone, right? We can all track people on their phones with your location services turned on, or your AirPods, or the AirTag that you put on your dog's harness, or whatever. Instead of having that, and a specific authorization for that specific thing, it's also opening it up for police to ask for similar things that are unknown at the time. So anything else, any similar item. Well, what's similar? There's no definition in the bill. This is wild. So they can get a tracking warrant to track your vehicle. And of course, your vehicles, modern vehicles now have data that allow them to be tracked. They can get a warrant to do this. And then that warrant can authorize a similar thing, which theoretically could be an authorization for the tracking of your phone, of your purse, or any AirTags you have, of your AirPods. As long as there is a basis, the police have to provide a basis to demonstrate that they believe the person has the thing. But like when it comes to, the standard pieces of technology that people carry around, everybody has them. That's the assumption, right? Everybody has a phone. They're ubiquitous. So this really allows police to basically take your car and use your car to search your phone effectively. In the end, it's wild. Um, very, concerning piece of legislation. Okay, the last decision I want to turn to today is another case about why really people should not self-represent on impaired driving trials, which incidentally makes me think about the paralegal consultation, the regulated paralegals taking over the work of lawyers, and how the BC government wants to allow them to do summary conviction matters in provincial court, aka impaired driving trials. And these are people who would have presumably the same level of training and skill that an individual self-represented person would have. So this is the case of Reed. It is a case from the Ontario Superior Court of Justice, and it's an appeal from sentence that was imposed by the Ontario Court of Justice Brock Jones, who is a very, very smart judge. And unfortunately, the decision of Justice Jones was overturned. Basically, what was at issue here was the driving prohibition imposed on the Mr. Reed at the end of trial. So the way prior to the amendments, December 18th, 2018, there was case law that came out that said that if you were on a bail condition that required you to not drive, that your pre-trial driving prohibition under your bail condition would be deducted from your sentence. It's like time served for a driving prohibition. And that case really, I think, changed the landscape for a lot of people. But Parliament got a little tricky. So in Lacasse, this was the 2015 Supreme Court of Canada decision, it came to that conclusion. And the deduction of the prohibition was from an 11-year driving prohibition because the pre-sentence driving prohibition needed to be subtracted. When the code was amended, there were new provisions that dealt with driving prohibitions imposed following a conviction for impaired driving. And then the Supreme Court of Canada in the case of Basque drew a distinction between a punishment and a sentence. Like a punishment is different than a sentence. So a minimum punishment of a driving prohibition is not the same as a minimum sentence of a driving prohibition. And this was the issue that arose, was whether or not the prospective prohibition, the prohibition that arises on conviction for impaired driving, could include the pre-sentence driving prohibition time, or whether it didn't. And the court there weirdly followed the Ontario Court of Appeal in Boyle, which is funny because that was a case that was implicitly overturned by the Supreme Court of Canada in Wolf. It came to the opposite conclusion of Wolf, and Wolf's conclusion was upheld, or wait, I might have that wrong. I might have that the wrong way around. I think I do. In any event, Section 320.24 sub 5 of the Criminal Code sets out the different prohibitions to be imposed. And 5.1 says that a prohibition order takes effect on the day it is made. And so the prohibition it lasts for a year. It's a minimum punishment of a 1-year driving prohibition that lasts for 1 year, taking effect on the day that it's made. And so because the court, and there's a Saskatchewan Court of King's Bench decision that says that Parliament intends mandatory driving prohibitions to be prospective only, that amendment that changed as a result of the amendments in December 2018, meant that a driving prohibition was prospective only and could not be adjusted or reduced to reflect pre-sentence conditions. And so reducing a driving prohibition is no longer an option for a judge, even if a person's been on a bail condition for 2 years not to drive. Um, and the sentencing judge followed cases that were decided under the old uh, regime, and under the common law, and Parliament, unfortunately, uh, did it pulled a fast one and basically meant that the sentencing judge, Justice Jones, erred in reducing the prohibition to reflect the time served on bail, and there is no longer a power on judges to reduce this time frame. And then the worst part about this is that the entire case was moot because the 12 months had passed anyway. So, oh well. And yeah, just a bad decision, basically, for people who don't want to serve driving prohibitions and who've been on bail conditions not to drive. Also, a good thing to point to in dealing with cases where there is a driving prohibition under a bail condition, to try and persuade the court to vary the bail to remove that condition and maybe put someone on like restrictive driving, like a curfew from driving, or only driving with an interlock, or driving under conditions to and from employment or things like that. The fact that a person serves this bail condition with no recognition for it, and there's no possibility of recognition for it on sentence, means that those bail conditions are really, really harsh, and often, I would think, unjustified when less restrictive measures could be used to control the conduct at issue. I don't have a ridiculous driver for you this week, unfortunately. I am sorry to say. I have been just inundated with work and haven't had the opportunity to look one up. Normally, Paul is the one finding them. So you're just going to have to deal with the ridiculous parliament of the week, making the ridiculous law that has ridiculous consequences for people. And there you go. That's our podcast. If you have a driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law. Oh, and subscribe to my newsletter.